Yes.
Yes, my lord was asking me this morning about the response to the email from Miss Clough.
Yeah.
And I've been reminded it's dealt with by the judge.
Yeah.
Judgment in core bundle tab 7, page 154.
Yeah.
So you'll see at the very top of that page is the quotation from Miss Clough's email, and then you'll see 28th of March, Marta Koalik, so this is internally at IBM, noted the client is rejecting emails due to missing PO. Can you please arrange for credit and rebill? Mr. Rigby, again, internal. Client has rejected the invoice we've issued without PO reference. I can see Jacob questioned at the time. If the client has agreement to settle without PO, have you something in writing, contact? I would say this dispute is time sensitive due to value. Miss Hyman said, can't say I'm surprised. Then there are internal emails within IBM saying it should be credited. 6th of April, Miss Rigby sent an email, cleanest way to handle this for the invoice to be credited, reissued with the PO reference and so on. Mr. Smith stated IBM legal drafted a letter challenging the rejection of the invoice, but the letter was not sent. CMG meeting, IBM asked for purchase orders to be raised relating to the items. Same day, Tina Broadway of IBM sent Mr. Riley of Syskill requesting PO number. You see attached invoice rejected last month, no purchase order provided, please do raise advised. That was passed on to Leah Noakes, who responded reject, not to IBM, responded to Mr. Riley. Reject, we will need to consider how to advise IBM. Mr. Houghton, he was, I think, the CFO, sent an email to Ms. Noakes saying, what's it for? Would it be something we could apply set-off against, do you think? And Ms. Noakes sent Riley an email with suggested wording for a response, which she sets out. Only mentioned yesterday, even though it's dated a month ago, it didn't come through to me. I need to look into it, understand the details. Riley was uncomfortable sending this email because it wasn't true. He already understood the details of the issue, but he followed the instructions of...
So is this right? In short, it's all internal on either side, save for the meeting on the 26th of April and the meeting on the 3rd of May.
No, the meeting on the 26th of April, and the same day, the email from IBM, Miss Broadway, to Mr. Riley, also dealt with in paragraph 2.
Oh, yes. Yeah. So paragraph 293 refers to, as it were, communications between the parties, and again then at 298 and 299, because those are the next two meetings.
Yes, exactly.
Yeah.
But my lord, there's one other thing I want to show you, just because it's in this time frame, and that is in the supplemental bundle behind tab 10, where you have an extract from a letter from Adelshaw Goddard, who by this time solicitors have been instructed on both sides. You'll see at page 137 behind tab 10. They're writing on the 13th of April, so right in the middle of this time frame, to CMS Cameron and Kenner, my instructing solicitors. You'll see under the heading Notice of Dispute, it says this letter constitutes a formal notice of dispute. And your lordship would be delighted to know we spared you the next 29 pages. Yes. But if you go to page 138, you'll see under the heading Set Off, paragraph 179, they said this. By reason of substantial loss and damage Syskill is clearly incurred, and so on, Syskill reserves the right to exercise its right to set off any IBM invoice which properly fall due for payment against a much larger claim, and so on. It will assess this on a case-by-case basis as invoices are tendered or are said to fall due for payment. Any decision by Syskill to make payment of a particular invoice, even if disputed and paid under process, should not be construed as an acceptance that any other invoices tendered are due and payable or waiver of its general set-off rights. So they're going to tell us on a case-by-case basis as invoices are tendered if they're going to challenge it.
Okay, that's very helpful. Thank you very much.
Lord, issue 4. The short point is this. We say if the contract hadn't been terminated, Syskill would not have recouped the sums which it had expended because of a change in the strategic direction of its business, and that there is sufficient evidence to rebut the evidential presumption which we have to meet. Can I take you first to the judgment at paragraphs 30 to 31? It's behind tab 7, starting at page 92. And where the judge records in paragraph 30, in 2014, Syskill was advised by consultants Deloitte his options were either to keep the existing system with enhancements and move to the bulk group infrastructure, lift and shift, or transfer to a new technology solution, replatform. The investment requirements for each option would be similar, but a new IT system would provide long-term cost savings and would support Syscal's strategy to become a market-leading digital and database business. The Syscal board decided to pursue the new IT system as its preferred option. So that's in 2014. And then if we could turn forward, please, to page 127, at paragraphs 183 to 184, and the judge records this. Mr. Summerfield, he's the chief CEO of Syscal, Mr. Summerfield explained in evidence that following termination of IBM's involvement...
Sorry, which page?
Sorry, my lord, page 127.
127, sorry.
Paragraph 183.
Yep.
Mr. Summerfield explained in evidence that following termination of IBM's involvement, Syscal entered into an initial contract with CDL Strata in respect of an alternative platform, but ultimately decided not to proceed with them. In autumn 2017, early 2018, the strategic direction of the group changed. It decided to move away from capital-intense businesses, including insurance, and moved towards a distribution business. In February 2018, the Co-op Group entered into a contract to sell Syscal to Marker Study. The bank separated from the group in January 2020. So, my lord, that is the background, and which is a decision to change strategic direction and a sale of Syscal to Marker Study, which meant that there was no longer any need for Syscal to have its own IT platform. Now, my lord, can I invite you now to go, please, to Supplemental Bundle tab 14. And look at what Mr. Summerfield had to say about this. It's tab 14, page 147. And my friends, thank you to some of this, but not all. And if we picked it up at the bottom of page 147 at line 22, the question I want to ask you about what actually happened following termination. What did happen, Mr. Summerfield, immediately after termination? What did you do? And then he said about issuing regulatory news, and that was a literally correct answer. And I asked the question again at 4, what did you do in terms of replatforming exercise that had been underway? And he explained, we looked at the Plan C work that Darren had begun, started to develop some of the components within it to a greater level of detail. Didn't you start working with CDL Strata? We're already there, and so on. And I asked him, did you enter into a contract with CDL Strata? We did, to begin some investigative work, yes. So essentially what you did was you looked at another replatforming exercise with CDL Strata. We were looking at the feasibility of it. How long did that exercise continue for? Various forms, probably through to Q2 2018. Then at 23, then you decided not to go ahead with that option. Is that right? We did. Why was that? In the meantime, in the autumn of 2017, the early part of 2018, Co-op Group was reviewing the portfolio of businesses it owned. It made a decision that it wanted to move away from capital-intense businesses. Co-op Insurance was the final financial business left within the group. Relative to the other businesses that Co-op owns for the return it makes, Co-op Insurance is highly capital-intensive because of the regulated capital we hold, and therefore the group preferred to exit that capital-intense activity and move towards becoming a pure distributor of products. Question, so what happened after this? Happened is this, isn't it? After the termination, you entered into a contract with CDL Strata for what was envisaged to be a replatforming exercise. If you had proceeded with that, you would have reused, wouldn't you, a lot of the work that had been carried out for the purpose of the Insurer Suite solution. Answer, we didn't enter into a contract with CDL for a replatforming. It was an exploratory piece of work. Had that exploratory piece of work turned into something, then prospectively, there were aspects of the previous work that could have been beneficial. And then I asked him a bit about that, and he says over the page at line 5, we installed nothing. And at 7, he said, we never wrote a policy on the CDL system. We never managed a claim on the CDL system. CDL doesn't even cover claims. We never used it. And I asked him, the reason it comes to an end is not because it's necessarily offering a bad solution or because you can't use what you've already done. The reason it comes to an end is because the business requirements of Syscal changed. That's right, isn't it? No, the reason we stopped the CDL work was the strategic direction of the group changed. It wanted to divest one of its subsidiaries, Syscal. So the need for a platform at that point in time no longer existed, as the expectation was, by divesting the legal entity, the purchaser would migrate the Syscal business onto the purchaser's platform. Indeed, you're still trying to do that. and so on. And he says, yeah, there is, correct, that's public information. Over the page, Marker Study have their own platform, don't they?
Well, we've read all this.
And then, yes, you read that about Marker Study, but then my learning friend went over the page, and an important piece of evidence here, when the group board made the decision, it probably was about February 2018, soon thereafter to divest, we continue to invest today in the as is, and so on. And the expectation was during broadly a 12-month timetable from going to market, an acquirer would take the business, the policies, and put them onto their own system. Now, my lords, that was then revisited in re-examination behind the next tab at tab 15. And passage my little friend didn't read, starting on page 159, line 20. You were asked questions about the wasted expenditure, and there was a discussion between you and my learned friend in relation to Co-op Group's decision to sell or divest itself of the Cisco business. Are you able to help her ladyship as to whether there was any connection between IBM's performance of the MSA and the board's decision, the group's decision, to divest itself of Cisco? Answer: there was no connection there. It wanted to be out of capital-heavy businesses. And then the bit which my learned friend did read to you, had IBM performed, what would have been the position? And you get his sort of speculative answer that was read to you.
Yeah.
Now, my lord, Mr. Summerfield's initial answer in re-examination, one my learned friend didn't read to you, was of course the exact opposite of what the re-examiner had hoped he would say, and that's why I asked his next question, gets a bit of speculation. We suggest that Mr. Summerfield's evidence was sufficient to rebut any presumption that Cisco would have recouped its investment through revenue or savings. That is because, quite independently of IBM's breach, there's no connection there, the decision to sell Cisco to an acquirer who would take the business, the policies, and put them on their own system necessarily meant that the costs of the project would always have been wasted. Cisco would never have recouped its investment, and to award revenue or savings in the amount of the wasted expenditure would be to treat reliance loss as an independent measure and so on, and to allow Cisco an escape from what had become a bad bargain, thereby putting Cisco in a better position than it would have been in had the MSA been performed. Now, the judge didn't deal expressly with this point.
Well, shall we start at the beginning now? I understand that's your case. Was this pleaded?
Yes, I'm about to, exactly about
well,
to.
That's the starting point.
Yes.
I indicated at the start. So can we look at that?
Yes. Yes, all right, my lord. Supplemental skeleton. Sorry, they raised 2 points. Let me just find my note if I may. It's core bundle, tab 16, paragraph. No. I'm so sorry. Yes, core bundle, tab 16.
Yeah.
Page 348.
Yeah.
Paragraph 54. Had the project been successful, it would not have resulted in any increase in the claimant's profitability or revenues. Consequently, the principle of law to which the claimant refers has no application. And that is responding, to turn back to the previous tab, at 55.2, page 346. It is said, as a matter of law, such a claim does not depend on there being a total failure of consideration. It's settled law. The costs incurred in reliance upon a counterparty's performance of a contract and wasted as a result of the counterparty's repudiatory breach may be included in the wasted expenditure claimed as a proxy for the damages to which a claimant is entitled in order to put it in the position it would have been in had the contract been formed. So we say, had it been successful, it wouldn't have resulted in an increase in their profitability or revenues.
So they're the two general propositions.
Yes. So
back to the point you were making this morning about putting people on notice of what the points actually are. There's no reference to the sale of the business.
No, my lord.
No.
If you'll
So
allow
there was
me
no
to-
evidence, other than the bits you've shown us of the oral evidence, there was no written evidence dealing with that as a causation point or or indeed a counterfactual.
No, and let me explain why. Because IBM's, that pleading of ours was dated, as you can see, the 31st of October 2018. That was at a time when we knew very little about what had happened following the termination. And of course, our ability to develop a pleaded issue before trial about what, if anything, Cisco had done was dependent on them providing, Cisco providing, proper disclosure and evidence, which Cisco resisted. Now, my lord, if in this same bundle, in the core bundle, sorry, supplemental bundle. In the supplemental bundle, could we go please to tab 11, which was the witness statement of Mr. Summerfield, and on page 140 at paragraph 6,
Yeah.
final sentence, Mr. Summerfield in his witness statement said, in January 2019, the Co-op Group announced its intention to sell Sysskill to the Marker Study Group. At the time of making this witness statement, the transaction is still in progress. No further details were given. As a result, that was a witness statement of the 12th of July 2019. One then goes to the next tab, tab 12, on the 9th of August. So shortly after receiving that witness statement, CMS wrote to Addleshaws referring to Sysskill's ongoing disclosure obligations, and saying in relation to quantum there's no cut-off date for the purposes of disclosure, saying there may be additional disclosure for Sysskill to produce. And at 1.3 over the page 143, they were asked expressly, what are Sysskill's intentions regarding its current and future IT systems following the completion of its sale to Marker Study, particularly in light of Mark Summerfield's evidence that the final separation of the network has not been concluded and Sysskill and the Co-op Bank still remain on the estate. The reply is behind tab 13, 14th of August, paragraph 1.3, you are not entitled to information regarding Sysskill's potential sale. Effectively, Sysskill chose to limit the information available to the court and to IBM on this issue. It's quite wrong.
So was there an application for specific disclosure?
No, there wasn't, my lord, but...
Was there an application to amend?
In what sense, my lord? The
To
evidence...
take the point you're now seeking to raise in the Court of Appeal?
Well, my lord, the point first emerged in the
My question is, was there an
No, there's
application
not
to
an
amend?
application to amend, but my lord...
So there's no application for disclosure, there's no application to amend, and then I think, don't we come to the judgment, because is this right? This isn't an issue at paragraph 191.
It's not identified in the judge's list of issues, that is correct. That's her summation of the issues. There were two key issue lists actually prepared for the trial itself, and on one of them, one of the issues identified was whether, as the claimant contends, it has incurred and wasted expenditure amounting to 1 to 2.8 million.
Yes, that's that point. I'm more interested in the specific point about it was all wasted anyway because of the sale.
Yes. Well, but my lord, and I always find this rather odd, if I may respectfully say so, that a party who has failed in its disclosure obligations is when courts will frequently say, if you don't disclosure, I'll be prepared to give disclosure when you should, I'll draw adverse inferences, is then allowed to rely on effectively its decision not to reveal relevant information, and somehow the party that hasn't sought specific disclosure, when it doesn't know what it truly is seeking specific disclosure of.
Well, again, coming from the TCC, I'm used to cooperation. If somebody says, look, this category of documents is material to the case, you're saying I'm not entitled to it, I am, you make an application for specific disclosure.
Well, but my lord, we didn't...
I mean, the point, we get to the point, this point, the judge doesn't deal with this.
No, the judge doesn't.
So it can't arise as a matter of appeal against the judge's judgment.
Well, I
mean, that's the difficulty we have.
It was very firmly on the plate because there were written submissions.
This judge worked like a Trojan.
Absolutely.
To deal with all of the points that were, as you put it, on the plate. This wasn't on the plate. She sets out the plate at 191.
Well, my lord...
Did you comment on her judgment, saying that you haven't dealt with this issue, which we think is very important?
No, my lord. But we didn't need to because we had won on the exclusion clause.
But you were proposing to rely on it as a respondent's notice?
Well, but not until we'd received a notice of appeal and we were much further down the road. But my lord, it is an odd position, I would submit, for this court, indeed any court, when it's confronted with evidence that's very clear.
No. I completely reject that, I'm afraid. You're referring to bits and bobs of a 39-day trial. In many ways, this case stands or falls on one answer in re-examination. That's not fair if it's not an issue which has been clearly pleaded, evidenced, and raised. It's just not fair.
My lord, fairness is a two-way street.
I agree.
And
I
it's
agree.
not fair, I would submit.
Judges have to deal, surely judges have to deal with the issues between the parties. And this judge did. And she didn't deal with this. I mean, there's a suggestion somewhere that the judge didn't deal with this because of her view on the exclusion clause. That's plainly not right. Because if that were right, she wouldn't have done the extra work that she had to do to identify what the wasted costs were. So she has tried to deal with every point that, as far as she was aware, was in issue, and this point wasn't.
Well, my lord, your lordship raised the question of fairness, and I do respond on fairness, because it's not that we hadn't raised the point. It's there, it's pleaded. In general terms, yes, but it is raised. It's clearly on the pleadings. We asked for disclosure, and it was refused when it should have been given to us. Again, you can say we should have applied for specific disclosure, but who actually is really the person to blame for the lack of that evidence? It's not us. The evidence is under the control of CISCL. They're the ones who know what's going on. And then we ask questions. I didn't know what Mr. Summerfield was going to say in answer to those questions. In that sense, it was a risky piece of cross-examination. But he's the CEO after all, so it's not as if he's someone who doesn't know what's going on. When he told us perfectly clearly exactly what had happened, and that it had nothing to do with the experience that they'd had under the MSA.
Well, that bit, on your case, that bit is the answer to the first question in re-examination.
Quite, exactly. But there, so he.
But there it is.
This is
so an issue that had never arisen before, suddenly this looks as if it might be a runner. Well, now, I understand all of the points you make about how that position was arrived at, but you know, looking at the thing overall, it's a very odd position to be in, to say, well, we take this point not because we criticise the judge, because the judge didn't deal with it, because the judge, honestly but mistakenly believed that it wasn't an issue? I mean...
But my lord, I don't think she could have thought that because of the written submissions which aren't before your lordships, but which covered this point. But my lord,
Well, those are reply.
Well, I mean, we need to explore this, because the point... Because of the way in which this point has emerged, the CISCL took the point, oh, it's much too late. So, I mean, this is the first time, effectively, that we're hearing what is said in answer to that. So that's why I'm
yes, you
interested.
were told we hadn't pleaded it, my lord.
Sorry?
You were told we hadn't pleaded it.
Yes, and
we have.
Well, your submission is that plea is sufficient. Yeah. Okay. Is there anything else you want to say about that point?
Well, my lord, I do submit that particularly where there is a claim here for what is called wasted expenditure, and if your lordship allows this appeal, IBM is going to be asked effectively to pay 85 million or something like that. and you have very clear evidence before you that actually that expenditure was not going to be recouped by Sisskill, very clear evidence to that effect, from the CEO of Sisskill, it would be unfair, to use your lordship's word, simply to ignore that evidence when the only reason it comes to light so late in the day is because Sisskill chose to sit on that information, and it's not until Mr. Summerfield gets into the witness box that we find out what's happening.
What's the answer to the point that Mr. Thank You made about the lack of any evidence about the counterfactual?
Well, but my lord, there is plenty of evidence because we have Mr. Summerfield dealt with.
Your questions aren't based on the counterfactual.
Yes, but it's his answers I'm relying on, not particularly my questions.
Yes, but your questions aren't premised on the basis, what if IBM had fulfilled the contract?
Oh, I see. Yes, sorry, let me...
That's the counterfactual,
yes.
And the complaint is, well, there's simply no evidence on the counterfactual.
Yes, can we? There's a fundamental point of difference between Ms. Thank You and I on the counterfactual that we need to address initially, and that arises. Can I show you it? It's in paragraph 45 of my learned friend's supplementary skeleton. So if we could go, please, in core bundle tab 5 to page 77.
Yeah.
And paragraph 45,
Yeah.
it said, the question of what Cook would have done if IBM had not repudiated was barely explored, only submitted relevant. The applicable counterfactual is one in which IBM not only refrained from repudiating the contract, but also fully performed it. Otherwise, IBM would benefit from its own breaches. Now, with the greatest respect, that is not correct. It would be right if the repudiatory breach relied on had been delay or bad performance, but that's not the position. The repudiation for which the damages claim is being considered was an entirely unrelated breach, namely wrongful termination of the contract by IBM. And in that Sisskill's loss flows from the repudiation, the relevant counterfactual is what would have happened but for the repudiation. So the starting point is the state of play as at the 27th of July 2017, and IBM is not thereby benefiting from its performance breaches because those were the subject of Sisskill's separate claim for damages, which the judge awarded. So what was the state of play in July 2017? If we go back to the judgment, tab 7, paragraph 162, which is page 120. We see in March 2017, Mr. Kuma, who had been brought in by Sisskill, prepared a paper for the Sisskill board setting out mitigation plans for the project. And if you turn over to page 163, thus by this stage, the risks to the business caused by continuing delays and failures to deliver the project were escalating. At the same time, Sisskill was questioning whether it was commercially advantageous to remain in the 10-year service agreement with IBM. And then if we turn forward, please, to the judgment of paragraph 396, which is at page 177.
Yeah.
And this was, Pasha, I couldn't remember the reference, I mentioned it earlier. At 396, the judge said this: having read the contemporaneous documents and having listened carefully to the factual witnesses, it's clear that by July 2017, both parties were resigned to abandonment of the project. Both parties retained legal teams and tried to manoeuvre themselves into a position where they could extricate themselves from the MSA with minimum damage. A high-risk strategy was adopted on both sides. The AG5 milestone payment, a modest sum in relation to the high value of the overall project, was the vehicle used to bring the project to an end. Both parties took a decision not to operate the contractual disputes resolution procedure to resolve the AG5 invoice dispute until July 2017, and so on. And final sentence of that, where Mr. Perrott called Mr. Summerfield to tell him that IBM decided to terminate, neither party made any attempt to save the project. So the position as at July 2017, when IBM was found to be in repudiatory breach of the agreement by terminating it, is that both parties, the judges found both parties were resigned to the abandonment of the project. So what would have happened if IBM had not terminated? In our submission, there are clear answers from Mr. Summerfield. A sale would have happened in any event, because there's a strategic change of direction by the Co-op Group, which has nothing to do, absolutely nothing to do with what IBM was doing, because it wants to get out of capital-intensive businesses. In those circumstances, in my submission, the counterfaction is sufficiently considered by the judge in her judgment, in the sense of identifying what the position was in July 2017, that there is nothing there that could rebut the very clear evidence of Mr. Summerfield as to what happened or what would have happened in relation to this platform. The suggestion prompted in the second round of re-examination that the group would have kept the business running is completely contrary to what Mr. Summerfield had said earlier on was the strategy of the Co-op Group of divesting itself of capital-intense businesses, and indeed to the judge's finding to that effect. And the speculation that Syskill could have been sold for a greater sum is just that, speculation. But in any event, it wouldn't be a claim for a loss suffered by Syskill. That would have to be a claim for a loss by its shareholders. So in our submission, there is ample evidence there. The point was raised on the pleading, albeit in the absence of particulars, but that's not our fault. And confronted as this court is with the proposition that if the appeal fails, Syskill should get 85 million, there is in our submission, we have done enough to rebut the evidential burden which is otherwise on us to show that they would have recouped that 85 million from this system. It simply wouldn't have happened.
Why does it follow, which it must do inevitably on your case, the sale by the Co-op Group of Syskill would have led to Syskill ceasing to use the platform? I mean, as it happened, it did. But why would that have to have happened on any scenario?
Oh, because Syskill was selling to a buyer that had its own platform and that would use.
That's what happened. Was that
Yes.
inevitable?
Well, maybe that. No, of course not. No, I mean, I suppose one could envisage as a start-up buying it, I suppose, and deciding to adopt the system.
And if that happened, your point falls away, doesn't it?
Yes, but there's no evidence. The evidence of what actually happened, and after all, we're in the real world, not the hypothetical world on this point. The evidence of what actually happened is that they were bought by Marcus Study, which had its own platform.
That was without a proper system. That was without the system that had been promised by IBM.
Yes, but as Mr. Summerfield said in that extract of evidence that I read to you, they explored with CDL Strata, which is another platform provider, an alternative system, and effectively they brought all that to an end. And the reason they brought that to an end was because they were going to sell Syskill, and then concluded a sale in February 2018 to a buyer who had its own platform. And my lord, that's July 7, 2017 is the repudiatory breach, the termination. February 2018 they sell to Marcus Study. So, my lord, I can in my submission properly rely on that.
Did you say that this point was taken in closing submission?
Yes, my lord, I think my learned friend's going to say that it's taken in reply submissions. I'm afraid I don't actually have the submissions here with me, but it was certainly a point that was rehearsed in the written submissions that were put before the judge.
It was the final closing submissions after the conclusion of the evidence. That was the point I was rising to make. Following this evidence you've seen from Mr. Summerfield as well.
And it was raised in reply submission.
First.
And did your side object?
We responded saying it wasn't properly in evidence and wasn't properly before the judge. It was an issue.
Well, I think for completeness, then we'll have to have not the submissions, all of them, but the bits that deal with this point, the extracts. So what was the sequence then? The IBM submissions were they sequential or were they
No,
simultaneous?
they were simultaneous exchanging. So, my lord, because it was the beginning of the COVID crisis, what happened is that written closings were put in, and then we didn't have a final oral hearing.
No.
And so further written reply submissions were put in. But, my lord, I'm sorry, I haven't looked at those submissions for a while. I don't remember.
So the original submissions were mutually exchanged.
That's my recollection.
And so there was a reply to the reply.
No, I misspoke. So there were 2 rounds.
Two rounds.
Yes,
so there
yes,
was a
yes.
mutual exchange.
2 rounds of mutually.
When you don't have a sequence, there's always 2 rounds. That's
Yes.
why you always have a sequence. So the first lot of submissions were mutually exchanged, and then when people saw what the other side was saying, there was a second round.
Yeah.
And it's in the second round that
The second round was where we responded to their first round of closing submissions.
So
Right.
we must have put it in our... Yes, so it was in
Your
our...
closing submissions.
Yes, I'm grateful. Yes, so it wasn't in our reply submission, it was in our closing submission.
Your closing, and then
Yes.
the point was taken in reply.
In reply.
It wasn't an issue for the judge.
Yes, and the judge didn't deal either with our closing or the point that was taken in reply.
But she seems to have accepted that it wasn't an issue before. It isn't recorded in the list of issues as an issue, and she doesn't deal with it.
Well, I mean, my lord, in a sense, I don't know that one can infer that any more than one could infer the suggestion I make, which is that she didn't deal with it because she dealt with the clause 23.3 point in our favour, and so it didn't arise. But
then neither did the figures arise, and she dealt with that.
well, but that's a slightly different point.
Well,
Because,
plenty of judges don't deal with the consequential points. You know, if I'm wrong about this, then that. I mean, that's another, as you can imagine, that can sometimes be a frustration here.
yes.
But as one would have expected, Mrs. Justice Zacaroli did. So I don't find that point persuasive. Anyway, don't worry, that's fine. If we could have simply the bits of your first submissions
yes.
and the Siskel's response submissions, that would be helpful. But just on this point, he emphasised.
I know we won't burden you with any more paper than you
Okay,
absolutely
thank you very much.
So,
Hang on, I'll just make a note. Yeah, sorry.
my lord, in which case that takes me just to the issue 5, the damages cap, the caps. So it's common ground, my lord, that if the appeal is successful, the damages are nevertheless capped pursuant to clause 23.5. The difference or the disagreement between us is whether Siskel can aggregate the 2 caps in 23.5a and 23.5e. They say they can. We say no, they are mutually exclusive. And if we could just turn them up, it's in the supplemental bundle, tab 1, page 41. And I appreciate you already looked at these with my learning friend, but subject clauses 23.2, 23.3 and 23.6, the supplier's aggregate liability to the customer group A, the implementation services shall be limited to 150%, and so on. And then B for the indemnity at clause 24.1, C for the indemnity at 24.2, D for each statement of work for programme related services, E arising otherwise under and or in connection with this agreement, limited to the greater of, and my learning friend accepts that if he's right, it would be the first of those, 15.7, and then F for willful default, and then the provisions of this clause shall operate as separate and additional liability limitations to all other limitations of liability in this clause, and any liability matters listed in this clause shall not form part of any calculation of whether the limits of liability under any other provisions of this clause have been reached. So, my lord, the argument for aggregation is that termination of the agreement brought to an end both the implementation SOW and the managed service SOW, and we submit, our first submission is that whilst that is correct, it's of no relevance. We say the applicable cap is governed by IBM's liability for the claim that is brought, and the claim that was brought was for wrongful termination of the MSA. It's not limited by the identity of the statement of work affected. The breach on which Siskel relies is a single act by IBM, wrongful termination, giving rise to a single cause of action, and that it's a single cause of action so that the liability cannot be both for the implementation services under 23(5)(a) and also arising otherwise under and or in connection with this agreement. The two, we would submit, are mutually exclusive, and that is what is meant by the word otherwise, because otherwise you are ignoring that particular important piece of language. Simple point of construction, in a sense, one can talk about this for ages, but it's actually a question of looking at it and saying, well, can they recover under both? Where there is one single event and the word otherwise in E makes it clear that it's meant to be a different event.
So just make sure I understand that. So you say it's a single event, a single cause of action, so it can't, and that triggers you accept 23(5)(a), and you say in those circumstances it can't therefore arise otherwise.
Yes, because yes, precisely. But my lord, that's our first point. The second point, and this is the point that even if you're against me on the first point, completely kills this as a relevant point, is that Siskel has not identified and could not identify at trial any losses which would come under the cap in clause 23.5a, but which could be brought, which would not come under 23.5a, but which could be brought under 23.5e. Now, my learned friend suggested that all of the sums claimed related to both statements of work, but that is simply not correct. And if I take examples from the three largest claims were IBM's charges. All of those charges related to the implementation services. They're all payable under the implementation statement of work. All of them. Second is third-party supplier charges. All of those charges related to the implementation work. All of them. And the third was for the bond, which was by which finance was used to pay for the implementation. And if I can take you in the judgment on this point to paragraph 690, and so it's core bundle tab 7, page 245.
Page, sorry.
Page 245.
Thank you very much.
Paragraph 690. This is where the judge was considering the bond interest and transactional fees, and the judge says Siskel relies on the evidence of Mr. Summerfield in his witness statement, and sets out an extract. And if you look at the final paragraph of that bit that's set out, Mr. Summerfield said this: the capital, and this was the evidence that was accepted by the judge, the capital raised through the issuance of the bond was deployed to strengthen Siskel's capital base, and although the funds were not held in a specific programme related bank account, the funds were critical to enable Siskel to cover the costs of the implementation of the new IT solution, and the amount raised and more was used for this purpose. So Mr. Summerfield's own evidence is it's used for the implementation of the IT services, and Judge at 695 says she's satisfied on Mr. Summerfield's evidence that the bond interest and the associated transaction fees were incurred in order to fund the IT project. So,
I answered your submission was that wasted expenditure doesn't exist, and it's a proxy for other things. And wouldn't those other things arise under both limbs? This is rather counter to your main argument, which is the wasted expenditure isn't claimable as wasted expenditure on either project. It's actually referable to what you would have received by way of revenue on the whole project.
Sorry, I'm not sure I fully understand. The sums we're looking at, these are sums paid by Siskel which they are seeking to recover as wasted expenditure.
Yes, but you say there's no such thing as wasted expenditure.
We say, no, that's right, we say that is just an evidential
And it's actually
device.
it's actually a proxy, an estimate, an
Yes.
evidential estimate for
Yes.
what you are really claiming, which is loss of revenue under the whole project.
Which is excluded, exactly. Yes.
Yes, but leave that to one
Yes,
side.
sorry, yes.
Now, my point is that I don't think on that basis you can seek to say that the expenditure must be attributable to one bit or the other. I think it must follow, mustn't it, that this wasted expenditure isn't just going to be, isn't a proxy for revenue under implementation. It isn't. It's in relation to the whole project.
But sorry, there are two separate points here. There's the what does the clause mean point, but the second point is a simple factual question, which is, have they actually incurred any expenses otherwise under and or in connection with this agreement? Or were all the expenses for which they are making their claim expenses incurred for the implementation services? Because if they're all incurred for the implementation services, they're all caught by the cap in 23.5a. I mean, if you're going to aggregate, if you're going to say I can claim under both A and E, you have to show that you've got sums that come within both categories. You can't just say, oh, well, I just lump it all together and make my cap a larger sum. So, I mean, the reason why there isn't a claim for the managed services is that no managed services were provided effectively because, of course, the system never got installed.
No, but they were going to be.
Yes, but they weren't. So if you're going to allow a claim for damages, which is loss actually suffered, then you have to show that you've actually incurred that loss in some way. But if they haven't actually incurred damages...
But they're claiming loss, aren't they, for the fact that the managed services would not in the event be provided?
Well, my lord, in fact, I think your lordship's point works, only works if you accept my primary submission on it being revenue and savings. Because if you're going to say, oh, well, they can up the cap because actually they would have recovered additional sums for the managed services going forwards, you could do that. But where they're actually claiming for sums which they say they have dispersed, they've actually spent them, then you actually have, the cap has to have some meaning, and the meaning has to be the sum incurred in relation, we would submit, for the implementation services, if that's what you're going to, if you're going to allow the main appeal.
So that's your second. Sorry.
Yes, sorry.
That's your second point under the cap. Your first is the question of construction, the otherwise point, and secondly, your point is that they would, in order, if you were wrong about that, they would still need to be able to identify losses that came under the managed services agreement, and you say they can't.
Yes, well, more than they can't. They've never tried to.
No.
So there was
and you say, well, the answer to that probably is because the managed services, as a matter of fact, were never provided because they never got that far.
And so how can it be said that those losses arose otherwise under or in connection with this agreement?
Yeah, well, I understand that submission.
Yeah.
On your first point, do you say that the word otherwise in E means that it can't be aggregated with any other of the heads A, B, C, and D? I know they don't arise on the facts. You say you go that far.
Well, without wishing to evade the question, I think it depends on the facts, because
well, this is a point of this is pure construction, isn't it?
Yes.
We have to look at the clause. So if we're just looking at the clause,
yes. So in theory, it could, if you had breaches which were clear breaches of different elements of agreements, then I guess you could. But sorry, that's why I'm being hesitant, because I don't want to say firmly yes or no, because I think it's slightly more nuanced than that.
So if on the facts, then they could establish that there was damage suffered by reference to the breach of the managed services part of the agreement, and there was damage suffered by reference to the breach of the implementation services part, then they could be aggregated.
Well, my lord, we say not, because there's only one breach here, and so we say you actually have to go back to the cause of action, and the cause of action for the breach is the wrongful termination of the contract. It's the wrongful termination of the contract that gives rise to the cause of action.
Yeah, that's your argument at stage 2, I think. But just in terms of pure construction,
Yes.
I'm asking if a claimant could establish that separate damage flowed separately from the breach of the obligations to implement the services and the obligation to provide the managed services, you would say, nevertheless, the caps can't be aggregated.
Yes, I would. Yes, I think that was my argument 1, actually.
No, it is. It is.
Yes.
I'm on your argument 1 only.
Yes, I'm so sorry. I'm being slow. Yes, I do say that.
You cannot aggregate them in any circumstances.
Yes, and yes, I do.
You can't aggregate E with B or C either.
No, because the keywords are arising otherwise, and you've got to give meaning to the word otherwise. And if you've got damages arising under E, D or B or C, then you've got to come within E. You've got to show damages arising otherwise. That's
So
the
there's a
point.
claim under one of the indemnities at some point. Then there can be no other claim. There can be no other claim for damages under the contract at all.
Sorry, the indemnities operate separately in clause 24.
No, to 23.5.
Oh, sorry.
B and C.
Yes, my lord. Those are separate. I would say those are separate.
So you can have both a claim operating under B and under E.
Well, I can see how you could certainly have one. For example, perhaps I can answer it different, because I think E is a problem because of the word otherwise. But you could certainly have claims arising under B and C.
So what about B and E?
But the moment you have E arising otherwise, it's got to be arising in a different way. So what you can't do is say there's a data breach, and I'm claiming both the indemnity for 5 million and also I'm saying and or otherwise I'm claiming because of that data breach caused me other losses.
Otherwise means under the agreement, otherwise than under A, B, C or D, doesn't it?
Yes. Well, there we are. Would your lordship just give me a moment? My lords,
Sorry?
That's the end of my submission.
Right.
Subject to any questions, Your Lordship.
Subject to any questions. We may have asked those as we go along, but I shall just check. We did.
Yes.
Thank you very much.
Thank you, my lord.
You may have noticed we did. Yes. Mr. Thank you.
My lord, do you still have 23.5 open?
Yeah, I'm not quick enough to have put it away in that time.
I just thought I might as well deal with that.
Yeah, sure,
straight away, because it seems to me that in my learned friend's answer to the last question, he basically accepted my construction of clause 23.5, because my point was that otherwise meant otherwise than in relation to A, B, and C, and D for what it's worth, although there weren't any such sales under D. And that was my construction.
Yeah.
And in relation to not identifying specific expenditure relating to the managed services. Your Lordships have my submission. It's not necessary for me to prove that particular expenditure was wasted in relation to specific parts of a contract which was a whole. The agreement as defined is the managed services together with each of the relevant sales. We incurred our expenditure in expectation of the entire contract being performed. Not necessary for me to identify particular parts of our expenditure which were specifically related to particular parts of that agreement. That would be that would be a nonsense in that submission.
So that means, in the circumstances that have arisen, that you would then be saying that effectively because it's one overall agreement, it's an automatic aggregation. I mean, you're not then looking at the individual, effectively the individual bits. You're just saying, well, because it's one overall agreement, and obviously the managed services were going to follow the implementation services, it's automatic that I would get it under A and E because they were incurred in expectation of both.
Yes. If there's a breach of the contract, then in normal circumstances, it's not likely you will have incurred expenditure simply in reliance on one part of the contract. If the contract is a whole, that would be pretty unusual application of the reliance damage principle.
But that might cut across the fact that there are different provisions. I mean, if there's one agreement, and I understand that, and that's how it's defined, but the aggregate cap doesn't work in the same way.
One can see, for example, with what the real purpose of E in our submission is to deal with the possibility of claims arising under B and C. In most normal circumstances, expenses will be incurred in reliance on both A and E.
Yeah.
And so really the main function of the otherwise is in relation to B and C, which may or may not, and D for what it's worth, given the NSA was obviously standardised wording, which was then applied in this particular context. But that's the situation in which the otherwise is likely to be engaged, is whether there are claims under B and C, because in most normal circumstances where there are two effective sales, claims will be, expenditure will in most circumstances be incurred under both A and E.
Okay, so anyway, that's
five.
That's five. Okay.
And then going back to issue 1, which was the construction issue. I don't think I have a huge amount to say. I mean, the aspect which my learned friends spent the least time on was actually looking at clause 23.3 itself. Mr. Tozzi had a run-up which would have made a West Indian fast bowler of the 1970s or 1980s very proud in terms of getting to clause 23.3, and then Mr. Kramer jogged back to the boundary, and put it that way, to use a cricketing metaphor. But if we just go back to 23.3, it is worth just focusing on the words.
Yeah, we're in there.
And the Lordship is faster than me, so I put.
Well,
I
we
put mine away.
were looking at the drafting delights of 23.5, and it's only up the same page, so even I was able to find that relatively promptly.
So looking at 23.3, we come back to our point in terms of identifying where in 23.3 wasted expenditure is said to be excluded, and really it boils down to a reliance on an argument based on a presumption that in the ordinary course one would expect to recover your wasted expenditure from making profit, revenue or savings if the contract was performed.
Mm-hmm.
And in our submission, wasted expenditure is a recognised category of loss. It is not the same thing as revenue, savings or profits. And it has been understood as a separate category of loss by generations of pleaders, contract drafters, courts and academics. And I laughed when Mr. Kramer referred to Professor Peel being an extremist, because really the extreme propositions were advanced by Mr. Kramer in saying that there is no such thing as a wasted expenditure claim and no such thing as reliance loss. We went through a number of authorities, including OMAC, where Mr. Justice Tier specifically mentions reliance loss as a distinct category, a distinct way in which one can claim one's damages. The point was that the overarching aim of damages is the same and based on the compensatory principle or the expectation principle. And really, legal theory shouldn't be allowed to waive, the legal theory tail shouldn't be allowed to waive the dog in terms of the principal task before the court, which is to construe the language of 23.3 in its plain and ordinary meaning. And that's the context in which we cited Mrs. Justice Mulder's decision. It's not to say it's binding on anyone or it's determinative of the issue, but it is a good indication of what a natural reading of a very similarly worded clause would be.
Well, Professor Peel makes the point that it'd be very odd indeed if by this exclusion clause, a contractor, IBM in this case, could exclude any liability for sums that have been paid to it for a project which it had repudiated and not performed.
Yes.
And in a sense, that almost takes one into kudos territory.
Yes.
Can a contractor really turn around and say, I know you've spent I know you've paid us 40 million for doing this project, but because you would only ever recruit that from savings, you can't do it. And his answer to that was, yes, well that is because savings must be net savings. Is that a point you take, or do you?
No, I don't rely on those kinds of nuances of drafting. I mean, certainly it's difficult to see what revenue and savings add to profit unless one's talking about net profit or net savings. But our construction is much simpler, as it were, and doesn't depend on any particular qualification to any of those words.
But equally, it is odd that a party who is expressly agreeing that they cannot recover any revenue which would have been generated by the system can nevertheless recover as much expenditure as they incurred, even though the only way that would be recouped ever would be by the revenue they would earn. And equally, that doesn't seem to make a lot of sense if, from an interpretation point of view, because it would mean effectively that anyone could avoid the exclusion by framing it as expenditure. The point Mr. Kramer made very forcefully, that can you, by the way you cleverly frame your claim for losses, avoid the exclusion clause entirely?
In our submission, we can. I mean, as Mr. Tozzi said, there are aspects of this clause which have redundancy and over-engineering, I don't. In our submission, to the same way in which reprocurement wasn't specified in the clause, if the parties had intended to include wasted expenditure in what was caught by 23.3, they would have spelt it out. And one isn't claiming anything in terms of revenue and saving, etc., by the back door. It is simply something which wasn't precluded by the contract as something that we could claim. The juridical basis is that there is a working assumption that one will recoup wasted expenditure in a particular way through earning sufficient revenue ordinarily, at least to break even. And that is the juridical basis on which one justifies a claim for wasted expenditure. But that juridical basis doesn't mean that the clause is extended to include claims which are wasted expenditure.
This is all the debate we've had about juridical basis. Really, there's nothing much between you on that. It's really whether or not that juridical basis should or should not cause one to interpret the exclusion.
Yes.
But effectively, does it mean that you read in the exclusion of a claim for wasted expenditure? Or alternatively, perhaps Mr. Kramer would put it, you say that well, it's actually a claim for wasted expenditure at all, it's actually a claim for revenue.
I mean, it would be odd, that would be a very odd result to end up with when one looks at cases like Anglia TV, and one looks at cases like Al-Ghusain, where, and you remember Anglia TV, Lord Denning said, even in cases where you wouldn't have earned any profits, or you can't show what you would have made on the contract. And in Al-Ghusain, the claimants actually tried to prove loss of profits, and Mr. Justice Leggett entitled allowed them to recover wasted expenditure, even in circumstances where he said it wasn't possible to say what the contract would have made. And so it would be a very odd result that an exclusion clause could preclude that type of wasted expenditure claim just by relying on the inclusion within the terms of the clause of revenue, profits or savings. And the problem with a lot of this debate is it's attempting to crowbar in principles which arise under the general law of damages into trying to construe an exclusion clause. But really one does have to look at it in terms of the way that a reasonable and ordinary person would construe it.
Just so that I'm clear, Mr. Thank you, do you accept the general point that my Lord made to you, that in fact there isn't very much between you on the juridical basis of a wasted expenditure claim? The point is whether or not that juridical basis gives rise to the construction for which IBM argue or the construction for which you argue.
That's right. As my Lord Justice Phillips put to Mr. Tozzi yesterday, when he was showing the court passages from OMAC, there wasn't anything in OMAC that I disagreed with. But we do say wasted expenditure and reliance losses are calculated and would be understood by most people as being calculated in a different way. In the real world, they're very likely to arrive at a different result than the juridical underpinning of it, in terms of where you end up in terms of pounds, shillings and pence. The theoretical basis for it is obviously a rebuttable presumption. But it's no more than a rebuttable presumption. And there was no answer to my point that a wasted expenditure claim is different in nature because it is for actual incurred costs. whereas a claim for loss of profits, revenue and savings is effectively a projection of unrealised benefits. And as I said at the outset, when dealing with Yamseng, you could see from the outcome in Yamseng what an incredibly valuable remedy the ability to claim wasted expenditure is. Because in that situation, the claimant was unable to show what the contract would have achieved, but they were able to recover their wasted expenditure. And that's why the juridical basis and the rebuttable presumption are no more than that. They don't drive the construction of the clause.
If you paid money under the contract to IBM, and then and the contract is terminated by their repudiatory breach, are you not entitled to recover those monies on a restitutionary basis?
Don't think so unless there'd been a total failure of consideration.
Well, if there's a contract provided with a system which has wholly failed, and you're left with nothing, why has it wholly failed?
I think the evidence was that some aspects of the system were usable, as it were, and could have been rescued. So I don't think we're in that type of scenario. So I think it is genuinely a wasted expenditure claim and nothing else. And all the authorities I took the court to in terms of the different basis on which reliance losses are assessed and so on, for example, Lord Justice Steyn and so on, they remain good law. And OMAC, I think paragraph 19 or 20, talks about the right of recovering reliance losses. And I think my Lord Justice Coulson mentioned that the point that concerned Mr. Justice Tier in the OMAC case was the risk of over-recovery, where they'd actually made a profit and hadn't lost, not only had not lost any money, but were better off as a result of the breach.
Yeah.
And that's not this case. So reliance losses remain alive and kicking. They're calculated on a different basis, but subject to the overriding compensatory aim, or the expectation aim, however one terms it. And one of the cases which is mentioned in Mr. Tozzi's skeleton argument is the Manchester Building Society case. I'll just give you the reference. It's paragraph 208 in Lord Borough's judgment. It's Authorities Bundle 2, tab 12, where the way he puts it is that reliance damages are capped by the performance or the expectation interest. And that's an accurate summary of where the law is. And he specifically refers to OMAC. It doesn't mean wasted expenditure or reliance losses have gone or been abolished in some way.
Sorry, what was the paragraph again?
It's paragraph 208. Mr. Tozzi mentions it at a site in the skeleton argument. I can't remember, there's a footnote it somewhere. Paragraph 208, Manchester Building Society, Supreme Court decision. And it's helpful.
Yes, but this is, I was just checking, because Manchester Building Society is a tort case.
Yes, it's an obiter remark.
And Lord Borough's, I think, may have been in the minority in any event.
Yes, it's an obiter comment.
Okay, fine.
My point is simply how he analyses the place of reliance damages.
Sorry, I thought that for one brief moment you were going to say we have to follow the roadmap in Manchester Building Society, and I think at 3:10 I might have committed Harry Kiri in front of me. Okay, so that's simply
if the court still has 23.3 open, I just wanted to make a point in relation to 23.4. Um,
23.4, yeah.
Your Lordships have the point that 23.3 consists of mutual obligations
Yeah.
in both directions. And then I think my little friend said something like in relation to 23.4b that there's some sort of carve out. It's not actually quite right. What 23.4 does is this provides a right to the customer, and B is the relevant paragraph. But you'll see it provides recovery in relation to procurement costs. But as you can see, and this is the point I wanted Mr. Tozzi to make sure you were alerted to, that is in the context of ordinary breaches of the contract, I can put it that way. It's not dealing with repudiation. So the references to 26.2a and 26.2b, where the contract is terminated for specific events.
Yeah.
So where there is a right where there is a right to terminate the occurrence of specific events. It's not addressing the situation of repudiation. So the only place in which reprocurement costs could be recovered in the context of repudiation would be in the context of 23.3. We say wasted expenditure falls into the same category.
Just on this 23.3, Mr. Tozzi was keen to emphasise on a number of occasions that the judge had found as a fact that the loss of bargain suffered by Syskill was, and I'm reading from the judgment, comprised the savings, revenues and profits that would have been achieved had the IT solution been successfully implemented. That's paragraph 682. Do you accept that? Is that?
No, in our submission, we would accept that that was one aspect. We obviously hoped to make revenue, profits and savings from the new IT system. But ultimately it's a question of law as to what the loss of bargain was. And our primary point is that we lost the contracted full system. I don't quibble with the judge also going on to say that we hoped to and we lost the chance of earning revenue, profits and savings. But the way one characterises the bargain the primary loss of bargain is the system we contracted for. And her conclusion there is not in the way that Mr. Tozzi suggested of binding finding of fact, which this court can't reappraise. But we would say there's no reason to depart from the way in which she approached the matter in Atos as to what the loss of bargain was, which is the loss of the system that the NHS Foundation Trust had contracted for. I think the only other point I'd make in relation to the exclusion clause in 23.3 is where the learned friends make the point that about the rebuttable presumption, as it were, and the recoupment through savings, revenue, etc. That omits the essential qualifier that there is a presumption of recoupment in circumstances where the contract is fully performed. If the contract is not fully performed, like here, wasted expenditure as a certain past loss is capable of being claimed in the alternative too, and separately from loss of profit, revenue and savings, which are inherently much more difficult to prove. And that's why the ability to claim wasted expenditure is such a valuable right, and why we do rely heavily, and the fact I didn't take you to the cases shouldn't underestimate the extent to which we rely on it. The principle of clear words being needed if a party is to be taken to agree to forego important rights. Brings us back to Gilbert Ash, the Stochnier case and others. They're critically important in the approach to construing 23.3. My lords, unless there's any other questions on 23.3, I was going to move on to issue 2. I was going to move on to issue 2 unless there's anything
right.
else. On
Okay, so because you've dealt with 5, and because you've dealt with 1, you dealt with the points on your appeal.
Yes.
Because those are the 2 points that arise on your appeal.
So I'm coming really to the respondents.
Yeah. Okay. Fine. So.
Subject actually 3 is slightly sui generis. Point issue 3 because it's raised in response to respondent's notice.
Yeah. Okay.
There isn't very much to say on issue 2, which I didn't say already in opening the appeal. Just by way of background, it arises out of the discussion that the court had with my learned friend in terms of the circumstances in which the AG5 invoice came to be issued. And it is useful just to remind ourselves of the judgment. I gave you some of these references in opening, but I didn't take the court to them. If one goes to paragraph 264, what I said yesterday was that IBM knew that the AG5 invoice would be controversial when it was issued in the light of the delays to the project. If one goes to paragraph 264 of the judgment at page 147,
Yeah.
see, this is IBM, paragraph 264. Jonathan Smith, risk consultant delivery, excellence SME IBM, understood that the invoice, that's the AG5 invoice, was controversial. I confirm that the issuing of the invoice is more a leverage tool. Contractually, the client should have issued a PO as there are no acceptance criteria around this milestone. It's date-based, but we do expect it to provoke a response from the client. And until we see the responses, we should ensure no revenue is recognised. And that is why paragraph 289
Hang on a minute.
page
What is she quoting from?
It's
At
an
264.
it's an IBM internal communication.
She doesn't have. Does it have a date?
It's in March, but I don't think I know off the top of my head what.
Okay. All right.
But I think your lordship can probably take it safely from me that it's around the time of the AG5 invoice. You can see from the surrounding.
So roughly contemporaneous.
Yeah.
We were sharing other emails around this time, weren't we?
Yeah.
Also in the judgment.
Yes. So what I was going to take you to was 289. I think this is what my Lord Justice Phillips may have in
Paragraph
mind.
289.
Yes, so paragraph 289 at page 154.
Yeah.
And you'll see this is again an IBM internal email where it said, "Can't say I'm surprised."
Yeah.
So IBM knew that the AG5 invoice would be controversial when it was issued.
Well, I thought that 287 was quite relevant because the response to the invoice being challenged for no PO was to suggest that that invoice would be credited and they would rebill with the PO. In other words, issue a new invoice. So the invoice that we're talking about, they seem to accept would effectively be written off and a new invoice issued.
Yes, indeed.
And if that's right, it seems to me it's very hard to see that they could rely upon the non-payment of that invoice as termination.
Yes, I would accept that.
again, 291, the cleanest way to handle this is for the invoice to be credited and reissued from clear reference. I have to make an assumption that as the invoice was disputed.
Yes. And that's, I think, one of the passages the judge relies on in showing that it was understood within IBM that the invoice as issued was disputed.
Yeah. I mean, this has to be looked at quite technically, it seems to me. And if they accepted that the invoice was disputed in a way that meant they had to reissue an invoice, that invoice.
Almost a dead
Repeating
letter.
myself.
Hard to rely on to terminate the whole contract. The only other point I wanted to deal with on issue 2 was the Al-Ghusain Principle and allegedly rely on our own breach. And in our submission, Mr. Tozzi impermissibly conflates two things. One is the obligation to pay the invoice, rolled up in it the obligation to issue the purchase order, and we accept the judge's findings on this, and that we were wrong not to issue the purchase order and wrong not to pay the AG5 invoice. There's no dispute. But that, what is that? He then goes on to conflate the entitlement to dispute the invoice in good faith. And that presumes that we were aware at the time that we were wrong in disputing the AG5 invoice and in not issuing a purchase order. There's no evidence to that effect.
Well, it seems to me that the reference to disputing in good faith encompasses the possibility that it may be disputed on incorrect ground.
Precisely.
And so it's very bizarre to say that is overridden by the fact that you're acting in breach.
Indeed.
It seems to me that it's implicit, that you may be acting in breach and relying on your own wrong.
And that's why I said in opening that the key language there is good faith. It doesn't say correct, it doesn't say in a way which a court ultimately finds to have been justified. It's good faith, it's a good faith dispute. And that carries with it, as your lordship suggests, an implication that you might be in good faith but wrong.
Well, good faith only arises if you're wrong.
Yeah, and that's where it becomes relevant. Indeed.
Well, can you? I think if you were disputing it on correct grounds, you would never get into good faith.
No, it wouldn't be necessary to have that
So
provision.
good faith necessarily implies a situation where the dispute is actually is a breach.
And the critical point to follow on from that is that the judge found that we believed we were entitled to act as we did. And that's why she finds that although Mr. Summerfield was wrong, the points he made were plausible and justified scrutiny, and that's why she held both that he acted in good faith and the obverse, that she found that he didn't act in bad faith in disputing the invoice, or in setting up the circumstance in which the invoice came to be disputed. And so it's a conflation of various factors, but accepting that we were wrong, there's no basis for saying there wasn't a genuine belief in our position, or that we didn't act in good faith. In fact, the opposite is true looking at the judgment. So, my lords, that was, I think, all I wanted to cover, unless there's anything else to issue 2. On issue 3, it's very short point. There isn't much to add. Yesterday I didn't pick up what my Lord Justice Phillips said, and then you said you wouldn't repeat it because I hadn't heard it. I'm glad I didn't hear it because it would have hurt my feelings. you said, so you're arguing that you didn't pay, but you paid, in effect. And I take the force of that criticism, but the answer we make might be viewed as unduly technical, but the point is this, that it's correct to say we didn't pay the invoice, and it's also correct to say that we disputed the invoice on other grounds, as we've been discussing. But the point on the set-off, and the reason why we say a set-off is not caught by the Schedule 5 time limits, is because a set-off doesn't involve any dispute as to the payability or validity of the invoice itself. And that was that's what one gets from the Ferns case. And the point your Lordship took me up on tender of payment, and the difference as to when that tender is accepted, and that discharges the liability. That's not our case, but it's no part of raising a valid set-off that the other party accepts the validity of the set-off you've raised.
Is it relevant in this context to see that clause 11.2 of Schedule 5 requires and therefore gives IBM the right to be paid by electronic transfer? So the payment envisaged by Schedule 5, clause 11, is one payment by electronic transfer, by real funds being transferred. And so if you're when you say you're not going to do that, you're disputing the invoice because you're refusing to pay as the contract envisages it will be paid.
So your Lordship was referring to, sorry,
11.2.
11.2.
Well, that wouldn't work with a credit note, would it?
Yes, I guess that's right. So it's not necessarily the only means of payment.
So a credit note might be additional, but we're not in that territory.
No, and it doesn't arise on the facts. But the payment would only be payable. The invoice would only be payable. So I'm trying to think on my feet. It's quite a tricky question. In my submission, 11.2 presupposes an invoice which is payable, and that brings me back to our construction of 26.7, and we'd say that although the invoice was undisputed, it wasn't payable because of the set-off being raised.
This I think goes more to the dispute point, because
Yes.
you're not doing what the contract envisages you should do with that invoice.
Yes. I would accept that, but that is in circumstances where we don't dispute the invoice, and in a sense, the payment, the 11.2 mechanism is only that, it's a mechanism for payment. But on our facts, there wouldn't be a requirement to make a payment, and we'd set off the set-off. But that's not on the basis that we're disputing the invoice as such.
That sometimes you dispute, you might dispute an invoice in part, but also think you've got a set-off.
And that's really what 11.11 in part goes to.
I mean, the fact that, in one sense, the fact that set-off isn't referred to at all works against you, I think, because the fact that it's not there at all means that since, it commonly arises, does that not suggest that it's under the umbrella of a dispute?
In my submission, the absence of any other reference to set-off is neutral at best. I mean, it probably means the parties didn't think about that possibility in this context, and really what I am addressing is whether the raising of the set-off falls within the terms of 11.7.
Whether an invoice is disputed or not is a different issue to whether or not you have paid.
Yes. That's right. But what I submitted in opening was that raising a set-off was, in a sense, tendering payment in relation to the invoices.
Yes, I'm just thinking about my Lord's point. In some way, if you're not going to pay by that means, that's a dispute. I'm not sure it's a dispute of the invoice.
Yeah.
Because you might well accept the invoice is payable, but pay it a different way.
In our submission, it could be categorised as a dispute, but we would say not within the meaning of this clause. Because it's not disputing the invoice as such.
But you do end up back in my Lord's postulation of yesterday, which I will repeat, which is that, well, in a slightly different way, in that you say, well, the set-off amounts to an acceptance of the amount. But that's never much good to the person rendering the invoice unless it's paid.
Well, it is, in the sense that the set-off will end up, if the set-off is correctly raised, the invoicing party will be better off because they will be able to deduct the amount of the invoice from the set-off.
As happened here in the judgment in 2021, some 4 years after the rendering of the invoice.
Obviously, if the spirit of this clause is pay now, argue later, then I can see the problems I face with that type of argument, if that's the spirit of the clause. Yeah. And my point is, I agree, technical one as to...
Yeah, I understand. You've been very clear and fair about how you presented that issue, yeah.
So, my Lord, that was, I think, all I had to say on issue 3. Issue 4 is causation. It has generated probably more heat than light. But if we just start with the judge's summary of the issues at 191.
Yeah.
As I said, I think yesterday, what the judge attempted, very well, if I may say so, was a distillation of the issues. And the reason her ladyship was not able to just to cut and paste an agreed list of issues was because there wasn't one. I don't want to deluge the court with documents, but we can. We can hand up the rival sets of list of issues. And what I would say, and I'm sure you would have been told otherwise if it were the case, that neither list of issues prepared by either party mentions the dispute we're talking about under issue 5. So, insofar as her ladyship's list of issues at paragraph 191 is concerned, it's entirely accurate and a fair distillation of the issues put before her by the parties in their respective lists. Now, in terms of the pleadings, in our submission, if we go to the back of the call bundle, paragraph 54 at page 348 behind tab 16. If that is pleading issue 4, it's in the most oblique tangential way possible. And to contextualise, that if one traces this back, this causation, this point made at paragraph 54 was in response to paragraph 55.2 of our reply and defence to counterclaim, which
Yeah, we looked at that on page 346.
which you looked at, which in turn was responding to a point made at paragraph 5A of the defence, which isn't in the bundle, which asserted that we could not claim for wasted costs paid to IBM in the absence of total failure of consideration.
Yeah.
So that is the evolution of this pleading and how it arose. Yes, if we go back to 342. 53A was what that was responding to in the amended. So if you read C53A,
Yeah.
claims for sums incurred with the defendant are not claims for wasted costs as alleged, but disguised claims for etc. So in our submission, it wasn't pleaded. The judge was right in her list of issues not to regard this particular point as an issue. And in terms of disclosure, there wasn't any in relation to this topic. I mean, we responded to what we saw as a fishing expedition by saying not entitled because it didn't go to pleaded issue. It would have been open to IBM to pursue an application for specific disclosure, and that wasn't done. They thought they were right in hunting down this point. And when Mr. Tozzi says that this issue was firmly on the plate, it was only placed firmly on the plate I said reply submissions, what I should have said was closing submissions after the evidence had been completed. It wasn't a point that had been opened. It wasn't a point which the judge distilled as an interview, rightly so. So if it was on the plate, it was after the evidence had been completed, and based on, as I think my Lord Justice Coulson said, on parts of cross-examination and re-examination without ever having been a properly formulated issue before the court. And if one's going to rely on one answer in re-examination from Mr. Summerfield, one does need to look at the whole answer. At the very least. And I took you yesterday, I wasn't going to go back to it, but I took you yesterday to where Mr. Charlton asked Mr. Summerfield what the situation would have been if IBM had performed the contract. And in those circumstances, he explained that Siskel might well have been retained, might have become profitable. But the real problem with all of this is that the counterfactual was never properly explored. And Mr. Tozzi really struggled to explain how the counterfactual was explored. He said the counterfactual was explored essentially in the question he asked Mr. Summerfield in cross-examination. But it wasn't explored through pleadings, disclosure, opening submissions, expert evidence, detailed factual evidence.
Well, the thing here is that you might have expected, if it had come out of the blue in re-examination, and there'd been no reference to this at all, you might have understand IBM sitting up and saying, well, hang on, here's a really good point, and we're going to raise it. And probably then you'd expect it to be raised before the evidence closed, so that it could be addressed.
Yes, they could have made an application.
But they knew,
trial.
but they knew from when they wrote asking for disclosure that this was floating around.
Yes.
And they chose not to pursue it. And although Mr. Tozzi says, well, it's a bit rich when you didn't give disclosure, the burden's on him.
Yes.
On his part.
Absolutely, and he accepts that the burden is on him. And just to track back, I took your lordships to Mr. Summerfield's witness statement, which triggered the Cameron McKenna letter, part of the chain that triggered it. But in fact, the sale to market study was announced publicly in January of that year, January 2019.
Would you say, in answer to the point that your skeleton takes the wrong counterfactual, because this is all about what would or wouldn't have happened but for the repudiation, so it's got nothing to do with delay, because repudiation in the events that unfolded didn't turn on delay?
I've got two answers to that. The first one is it's wrong as a matter of principle, because if one is going to run the bad bargain hypothesis, you've got to say that Siskel entered into a bad bargain when it contracted. You can't say, well, after all the delays that occurred, that's the counterfactual that one takes into account. Otherwise, how does IBM even begin to rebut the presumption unless it can show that we entered into a bad bargain? That's what the cases say. That's where claimants are not allowed to recover, where they entered into a bad bargain and they would have lost the money in any event. The second point, my lord, is that nowhere in any document served so far in this appeal or before the judge has this particular version of the allegedly correct counterfactual been articulated. One would search in vain in Mr. Tozzi's skeletons to find where this particular counterfactual that he's raised on his feet for the first time, 225 on day 2 of the appeal, is articulated. The paragraph I took you to, paragraph 60 in IBM Skeleton, what I said to the court yesterday was that he puts a lot of weight on the words would always, that our expenditure would always have been wasted. Pretty vague, but I took that as meaning we entered into a bad bargain and we would never have recouped our expenditure. So this particular version of the correct counterfactual is A, wrong, and B, this is the first time we hear it articulated. And how then was it supposed to have been articulated at trial and explored in the evidence?
In any event, even if the counterfactual is slightly different, because you look at the situation when there's been delay already, you have to work on the assumption that you would recover damages for that delay to put you in the same position as if it had been before.
Yes.
I'm not sure it actually ends up making a difference.
It may not make any difference at the end of the day, but one does have to, the starting point is to assume the contract had been fully performed in accordance with its terms. But at the end of the day, it may all come out in the wash, it may not make much difference. But in our submission, a fully performing IT system with a 10-year managed contract in 2016 is a very different beast to something which you're trying to rescue in 2017. And I gave the court yesterday, and one can take with a pinch of salt what the estimated release dates were at that point, given the history. But we were talking about many years into the future, even on the alternative counterfactual.
Well, I think one was 18 months and one, I think, was 31 months, something like that.
Lords, unless there's anything else that, or any questions the court has, that was all I was going to say in reply on issue 4.
No, we don't have anything else for you. Thank you very much. Right, well, as advertised, we are not going to be giving you an extempore judgment this afternoon. I'm sure you're unsurprised by that, but that is the position. We'll consider the judgments. There are a number of not straightforward points here, so we will take our time and we will send out the drafts in due course. Obviously, when you get the drafts, it's an opportunity to correct our spelling and grammar. It's not an opportunity to re-argue the case. And as a result of recent events, I'm asked to remind you that there will be an embargo on the draft judgment, which it's very important that people observe. You will both be aware that that didn't happen recently, and the Master of the Rolls is very anxious that it doesn't happen again. So,
My lords, I'm sorry.
yeah,
I said I would try not to exercise it. Can I have 30 seconds?
you can have 30
One
seconds.
very small point. It's
Yes.
on issue 4. It was what Millennium Friend just said a moment
Issue
ago.
4, yeah, the one
Issue
we've just
4,
done, yeah.
About the date of the counterfactual. And Millennium Friend said you have to assess whether it was a bad bargain when the contract was entered into. With
Yeah.
the greatest respect to Millennium Friend, that's simply wrong. You can, of course, the court of course is entitled to rely on subsequent events to see whether the contract that was entered into was a good or bad bargain. You don't just look at it in a vacuum. So on that point, I suggest Millennium Friend, with greatest respect, is incorrect. I don't want to say
Okay, well, that's another point that we'll have to consider.
yes, that's why I...
Yeah, no, that's fine. I just as long as I know what they are, I don't want them to arise subsequently. Fine. Right. Well, thank you both very much, and thank you to everybody behind you. And as I said at the outset yesterday, it's very nice to have a full court. I apologise to those of you who've had to wear masks for 2 days. I know these things are coming to an end, but HMCTS quite properly has always been concerned about the health risks, touching all available wood. The court services run pretty well in the circumstances. That is in part because we've complied with what might be thought of as overly strict restrictions, but we have. And so I apologise to all those of you who've had to wear masks. Thank you very much.